who are present here. I'm not sure if the Deputy Minister is in the platform. If he is, he's welcome. Then welcome the acting DG and the team. Welcome. I'm not sure if people from FIC are also in the platform and the media. Apologies, as I've apologized that even now I had to use a cell phone and struggle with the network. I have to go around my house here. Be that as it may, I'm now in the platform. Are there other apologies? There are
no apologies, sir.
Okay, there are no apologies. Let's move to item 3. Item 3 is the briefing by the National Treasury on the General Laws Amendment Bill, Anti-Money Laundering and Combating Terrorism Bill. Who's taking the lead? Momo, are you there? Or who is from Treasury? Who's going to lead in presentation?
Yes, Chair, I'm here.
Okay, over to
Chair.
you. Morning, over to you and your team.
Okay, no, thank you, Honourable Chair and Honourable Members, for this opportunity to present on the General Laws, Anti-Money Laundering and Combating of Terrorism Financing Amendment Bill. It's a big name. I'm going to call it General Laws. And we've got quite a big team from the Treasury. I won't introduce them all. We do have a slide. Nandila, are you putting up the slide, or Ellen, for the meeting?
Yes, Mom, I'm trying to get our colleagues to make us host. I requested them to make you actually host. So let's wait if they can do that for us.
Yeah, don't make me the host. I won't know.
I can run it for you, Momo. Let me just wait for them to make me co-host.
Okay. Okay, so I'll talk in the meanwhile, Chair. So we've got quite a big team from the National Treasury, from our policy staff, our legal staff. Advocate Van Spoor is here, and Advocate Janine Bednar-Beyosi is here. And then from the FIC, we've got Puvendri Naidu. I'm not sure if Advocate Peter Smith is out at the ISAM-Leg meeting in Lusaka. He's going to be trying to join us from, I see he's on. So, yeah, and there may be other colleagues as well. So, without much further ado, let me just start. I think honorable members will recall, I think it was in February this year, that we did present on this bill. Sorry, not on this bill. We presented on the next slide, please. We presented on the mutual evaluation. We went through with the committee the poor ratings outcome that we got as South Africa when the mutual evaluation was conducted in much of 2019, but with COVID went on in 2020 and a bit of 2021 because some FATF meetings did not take place. And they didn't do mutual evaluations when they did. So basically, ours was only published then in October last year, 2021. And I think just for honorable members, just to remind yourselves that in the presentation, I think we pointed out that we had failed in 20 of the 40 FATF standards. Okay, we shouldn't use the word core here, but we should say standards and recommendations. And to correct that is a process they call technical compliance, and that deals with our laws. And we failed in all 11 effectiveness measures. Effectiveness measures tend to deal with, you have the laws, how are you implementing it? And in FATF speak or language, they call immediate outcomes. So there too, we scored moderate and low effectiveness. And basically in both the two categories, FATF has 4 categories. And if you don't make the top 2, if you get the bottom 2, like moderate and low effectiveness, you're deemed to fail on that particular measure, and you've got to improve. I should add that 2019 was also a particularly bad year for us, just coming from the era of state capture and some of the weaknesses that you had in institutions like the NPA, the Hawks, and so on. So the timing was probably not great for South Africa with the new leaderships that had come in 2018. So anyway, that's where we are. We therefore, because of the poor rating, very poor rating, we face grey listing by FATF, which is anti-money laundering, international anti-money laundering body. It has 39 members. South Africa is the only member from Africa. But I should add that though it's 39 members only, when there are over, I forget the number, 180 countries or jurisdictions in the world, most countries belong to a regional formation. So if you look at on our continent, most of your SADC countries fall under a body called the SAMALEG, and then there's one in West Africa, there's one in Middle East. And through those regional bodies, they have a representative at FATF, and they too go through the FATF processes, because generally no country wants to be out of the financial system. And they want to comply with these standards, because whether they're members or not, if they don't, they're going to find it very hard, if not impossible, to trade with other countries in the world. Most countries are part of the FATF system. So because we're facing grey listing, we were put under what FATF calls the ICRG group, International Cooperation Review Group, and put under what they call an observation period for 1 year, which started in October last year and ends in October this year. And we also put under another process called enhanced follow-up process. Many countries that are not facing grey listing are put into a follow-up or enhanced follow-up process, where they got to report to FATF plenaries much more often to address their deficiencies. I should add, Chair, that most countries will have deficiencies, both in the FATF recommendations and in the effectiveness measures. So even if you look at the US, UK, you'll find that they'll have, I can be corrected, but when last I looked, they'll have at least 4 or 5 moderate outcomes. So they're also deemed to have failed in those. But because it's not as many as ours, they're not put on a grey list. They put on perhaps a follow-up or enhanced follow-up list. And they too have to, they're generally given about 3 years to deal with technical compliance, to address it, make changes in their laws and so on. Because we are facing grey listing, we have to almost do a significant amount within a year and a half. We might be given more time later if we've deemed to make good progress, but the big elephant is what happens between now and February, when we need to, when we go to the FATF plenary and they decide whether we've made significant progress up to then, and if not, they're going to give us an action plan that needs to be followed. And to prevent that, we have to report by the end of this month on technical compliance, and I'll deal with that, and a more detailed report in October, which is then used to engage with the FATF Secretariat or the joint group, as they call it, which I'll explain, over November, December, and January. And those become the recommendations that go to the FATF plenary. but I'll spell it out in a bit more detail, but just to give you a broad background of what's the road ahead for us. Next slide, please. So this is just for members. We've shown you this slide before, I think in our February or March presentation, or January, I don't remember when it was quite early this year. And you'll see that these are the 40 FATF standards, and PC means we're partially compliant, NC means we're not compliant, so that's the worst category. So we have this red and dark red in 20 categories. LC is largely compliant, which we have, and we are deemed to be fully compliant with a C. So that's quite a good measure. You'll see that we've got 3 that are fully compliant. So we have to address the 20. Normally, as I said, a country is given about 3 years, but we'll have to do it far quicker. Next slide, please. And then these are the effectiveness outcomes. So these are the 11 measures. And as I said, if you look at the left column, they call immediate outcomes. Very curious language. And you'll see that we've been deemed moderate in 8 of them, and in 3 of them, we are low effectiveness. Legal persons and arrangements, that's beneficial ownership, terror financing, investigating and prosecution, and terror financing, preventive measures, and financial sanctions. And we'll explain that as we go on. And you'll see the 4 categories that they have, and we score the low 2. So what's the core of the remedial measures that we have to address? We've got to address then the weaknesses, the deficiencies in the 20 of the 40 recommendations. And that process is called technical compliance. In particular, there's 3 which are regarded as core recommendations, 6. We okay on 3 of the 6, but on 3 of the 6, we are not okay. And that's what we really have to prioritize amongst the 20 that we have to address. We have to address the 3. And I say this is still the easy part because it involves having your laws reflect your commitments to these standards, and that your laws require you to implement it and to have it in place already. So it doesn't have to say it's still going to take effect, to have all the regulations and so on. So that's the easy part compared to the next part, which is where I think we are struggling. It's the effectiveness measures. Can we implement what we have in our laws? And that's where it's going to be tough, those 11 immediate outcomes. And there's going to be measures like, and I don't want to target just the police and the prosecuting authorities, but you'll see that there's 3 or 4 immediate outcomes that apply to them. And we will have to show as a country that they've, investigating the crimes that it doesn't matter who's responsible, whether you're a minister, you're a president, you're a public servant, whether you Steinhoff, whether you Tongad, all of those cases, there needs to be a sense that they are getting properly investigated without fear or favor. Secondly, that to the extent that some of them, there's prosecutions, that people are prosecuted, that the cases generally are successfully done so, that also in parallel there are freezing orders or asset forfeitures and so on. On the targeted financial sanctions, that when the UN Security Council lists someone as being designated to be responsible for terror financing, that South Africa has signed that agreement, that we actually gazette it in our country and ensure that legally everyone the banks and others have to act appropriately in terms of what the law requires or the international agreement requires. We've not been doing that. For example, for 5 years, we haven't actually gazetted even the list that's been there for, as I said, 5 years ago. And those should be relatively easy to deal with if we just get on and do the gazetting. But again, the proof will be in the pudding. It's not good enough to say we intend to do it, we're planning to do it. We've got to say we've done it, this is the gazette, this is whatever. There needs to be hard proof that we've done it. So that's where we're going to have difficulty. Next slide, please. So, Chair and honorable members, so what we've done is, we are focusing on the 3 core FATF recommendations, and what you're going to be seeing, and we'll also be doing the other 17 in some way. And, given the time constraint, because most of these weaknesses we obviously only saw last year, towards the middle and end of last year, and we've got to process with all the relevant departments because it requires changes to many pieces of legislation, the Companies Act, the Non-Profits Organizations Act, the Act on Trusts, the Poktatara Act, and we felt that all departments won't be able to do this, or ministries will be able to do this separately, and unless they were ready to roll, which was the case with the Minister of Safety and Security, the policing authorities were ready to put their amendments through. So they've, in fact, done the Poktatara bill. Don't ask me what it means. Something like prevention of organized crimes, and but the name will come to me. Maybe Peter or Puvendri can say just now what it means. Okay, it's a long name. So they will come in, and they've already tabled their bill last month, at least a month before us. And they deal with, and this is an important point, 2 of the core recommendations. So it's quite an important bill from that respect, because the 3 core recommendations, we must deal with that together with the remaining 17, but those are the priority amongst the 20. The second thing is that we said that those departments that won't be ready, will incorporate them into the bill we were preparing to amend the FIC Act and other financial sector acts like the Financial Sector Regulation Act. And so, therefore, this general bill is an omnibus bill. It covers 5 acts of parliament that need to be amended, and they fall under 4 different ministries. So given the time constraints, honorable members, the Cabinet had appointed about 2 years ago an interdepartmental committee, which is chaired by the DG of the National Treasury, to deal with anti-money laundering, that's AML, where you see the words, and combating of financing of terrorism, that's CFT. So there's been a working group with all the departments, Treasury, FIC, Justice Department, Social Development, Secretariat for Police Service, TTIC, CIPC, the Reserve Bank, the SARS, the Prudential Authority, the Financial Sector Conduct Authority. They've all been consulted and been part of the process. I've dealt with the effectiveness measures. Next slide, please. Okay, so this general laws bill generally then changes the FIC Act, the NPO Act, the Trust Property Control Act, the Companies Act, and the Financial Sector Regulation Act. Now, this bill will address 14 of the 20 technical deficiencies, and we spell them out, the numbers 7, 8, 12, 15, 17, 18, 22, 28. It deals with those recommendations. I know that doesn't total to 14. No, it does 22 to 28. So that should add up to 14. I hope I got my arithmetic right. And then the Pogdadara amendments, as I said, deal with the two core ones. So they deal with, in total, 2. That's 16. And there's 4. So they deal with recommendations 5 and 6. And there's 4 that are left. And those can be dealt with through regulations and secondary legislation. I'm hoping Puvendri can explain that at some point. Puvendri, do you want to come in and just explain that, or Peter? Just leave the slide.
Thank you, Mama. Good morning, Chairperson, members and colleagues. I will come in, but if I lose connection or if you can't hear me clearly, then Puvendri will take over and carry on. I'm dependent on the Wi-Fi connection that's provided by our hosts here at the meeting. The technical deficiencies that this bill will address are relate to specific findings of the assessment team in the mutual evaluation, where they analysed the legislation, not just the FIC Act, other legislation as well, and found that it doesn't fully provide for what the FATF expects in respect of these recommendations. Some of these are recommendations that we have to fix now in the short term as part of the observation period process, but many of these are also further amendments that we need to make and address in time that will also improve our ability to be more effective with implementing this legislation. And there's more detail on those in the presentation as well. I just briefly, most of the amendments that we're looking at here in the Act, such as the Trust Property Control Act, Companies Act, and some of those in the FIC Act deal with the concept of beneficial ownership, which is a serious shortcoming in our legislation at the moment. The capturing of the information on beneficial owners and making that available to authorities when they need to investigate that. And some of these, for instance, the Non-Profit Organizations Act are amendments that are required for us to improve the effectiveness of the implementation of our counter-terror financing measures, sanctions, targeted financial sanctions measures, etc. So we'll also explain those as we go through the clause-by-clause provisions. I think just to make the last point on sort of at a high level on these, many of the due diligence findings of the FATF that relate to recommendations 12, 15, 17, 18, 22 to 28 are minor things that we need to fine-tune in our legislation. So it's not necessarily that we're not covering the principles of what's required there in our current legislation, but the manner in which it's covered and the manner in which it was assessed pointed out that there are still daylight or a discrepancy between what the FIC Act or other legislation requires and what the FATF standard actually expects. So many of these things are addressing those at a level of detail rather than bringing in new principles that are completely foreign to our current framework. Thanks, Mama.
Thanks, Peter. And just for honourable members, I've just been reminded, POPTATARA stands for Protection of Constitutional Democracy Against Terrorism and Related Activities Amendment Bill. Next slide. So just for honourable members, just to say, where does this bill or these amendments fit in to the FATF grey listing process that we face? So the two bills, the General Bill and the POPTATARA Bill, as I said, address 16 of the 20 deficiencies and will allow us, and we'll be able to do the 4 others. And we'll be doing this in record time. If the bills are enacted into law, then it will be done in, say, 1.5 years. But even now, we'll be able to report in our end August report to FATF that the 2 bills have been tabled in Parliament. And that, I think, will be positive for us. FATF will be discussing the bill and so on now when we go in October at the plenary. It will do it at its next one, as I've said, which is in February. And but if we, for example, reported on no progress at the end of August, then perhaps they may have intervened, the way I understand the FATF process. But I think we should be okay for, given that we've tabled the bills, it does demonstrate commitment by government. And our hope is that by the end of October, we can sort of just show that through the parliamentary process, there's been significant progress. And definitely by the end of December, we want to be able to update the October report and say that the bills have been passed. And we need to make sure that the bills are in effect by January 2023 before we go in February. But these amendments, even if we pass them and they're all in effect, they're not enough to fend off a FATF grey listing. As I've been saying a few times, we've got to demonstrate we made progress on all the immediate outcomes, the effectiveness measures. And that's, I think, going to be the tough part. I should add that some of those measures don't need the law to be changed first for us to make that progress. They can be done now already with current laws. So, for example, if the investigating authorities have more cases and so on, in terms of current legislation, those would count as being positive. We need to have a national risk assessments. Those don't need a law. We can already update those and have a credible risk assessments just using the current law. On the targeted financial sanctions too, current law does enable us to already do certain things, which would help if we were to do it. Next slide, please. So we don't need to change the law to start making progress on the effectiveness measures. So it's not a situation where the law only comes into effect in January and then they have a month to do it. I just want to assure honourable members that, and we've been engaging with all these authorities to make sure that they are kind of ensuring that they can deliver on those effectiveness measures. And just to summarize them for honourable members, so the immediate outcome one, they deal with national risk assessments, what's our strategy to fight crime. I should add that basically, I guess what the FATF is saying is that, you know, the lack of effective enforcement and the way we've been implementing, in a sense, they're saying that we are too naive if we think that that's going to deal with criminal syndicates which are highly organized. I think we've seen, for example, you know, there's articles on the construction mafia, or you see the Zama problem, that clearly these appear to be highly organized criminal syndicates that operate. And our national risk assessment needs to demonstrate what are the priority areas for South Africa, and that we have a risk-based approach. And once you have a national risk assessment, we do have one now, but we're updating it for money laundering and for terror financing and a strategy. All our authorities as a country, we need to show that we align. So we're kind of working at developing one that everyone buys into and believes in, I should add. And we should be able to do this hopefully by October, November. Then you have immediate outcomes. I'll come to 2 just now, 3, 4, and 5. And they deal with mainly supervisory requirements that to demonstrate whether it's the prudential authority, whether it's the one that oversees estate agents. They've got a new name now. Whether it's the legal professional bodies that oversee their members and their behavior, that they have a risk-based approach, that they ensure that they are also fulfilling their obligations to report on suspicious transactions and so on, that they have a risk-based approach. And a risk-based approach means that they can't just have it in their heads. They got to have a manual. They got to show that this is how their operating procedures. And if they don't have the manual, it's taken that there's no proof that they actually do risk-based supervision. A lot of it also relates to beneficial ownership, because we don't have the law, that we need to begin to say who the ultimate owners are of companies, of trusts, of NPOs, who ultimately controls those organizations. That's going to be quite important to begin to put in place. Again, we don't have to demonstrate that we've got it all, but if we can show that we've passed the law, that CIPC has developed systems to do it, has started doing it for the big ones, that will demonstrate significant progress. If the Prudential Authority has its manual, if all the other supervisors have their manuals and so on, and in the legislation, as you'll see, in some cases we know that they aren't effective supervisors. It might just be a registration system. So if we deal with motor car dealers, nobody really supervises them. So the FIC will be coming in to act as their supervisors. I think that's also done through the schedules and so on. But Peter can correct me exactly which clauses deal with that. So, and I should add, obviously, if the schedules also are passed, it will be useful info that we can submit both for our August report, because I think there's been significant progress in Parliament with the hearing yesterday. And by October, we should be able to report on that as well. Then you have IOs 6, 7, and 8. And you've got to read that with IO 2, because that's with international cooperation. So that really refers to the police, the Hawks, the NPA, the Assets for Feature Unit, investigations, whether they have prosecutions, do they freeze funds that are questionable, do they try very hard to recover funds that have gone to Dubai by using the legal mechanisms that come in. Those are all issues that we'd have to report on. So it's factual evidence. Have you asked other countries or not? You'd have to demonstrate how many investigations have you had for which type of crimes? What type of people are you prosecuting? Are you able to do so for those that are highly connected politically? If you demonstrate any weakness, obviously that's demonstrates, well, that won't count for us. But obviously they need to act fairly as well, I should add. They can't just go out and prosecute people just to get their numbers up. They must do so because there's real cases and that lead to successful prosecutions. Then you have the immediate outcomes 9, 10, and 11, which deals with terror financing. This is an area that's really not been well developed. And I think that many of our institutions need to begin to factor this in. So they've been focusing on money laundering, but not on terror financing. And I should add that it's not that South Africa may be relatively free of terror attacks and so on, but many individuals sort of know that regard South Africa as a safe haven. It's easy to operate, and they may be funding activities in other countries on our continent, in Mozambique, in Somalia, in wherever else, and also in other parts of the world. So it's important that we have the mechanisms to stop that. So other countries expect us to act. So we'll have to demonstrate substantial progress, and have our own action plans for each of those. So we can say we've done this for each IO, but this we recognize we need to do more, because we certainly won't be able to have done everything. In fact, no country will be perfect. You'll always be improving your system. Next slide, please. So I've just put out a slide to show how FATF assesses effectiveness. They say it's assessed in a fundamentally different way to technical compliance. The assessor's conclusions about the extent to which a country is more or less effective should be based on an overall understanding of the degree to which the country is achieving the outcome. The core issues should not be considered as a checklist criteria. So for each of the IOs, there are two overarching questions which assessors try and answer. To what extent is the outcome being achieved? What can be done to improve effectiveness? So there's continual improvement. So those are the kinds of questions that they ask. This is taken from the FATF methodology on mutual evaluations. Next slide, please. Chair, this is just to show how we've been doing it at the level of officials. The Treasury chairs the Interdepartmental Committee. And given all those IOs, we have a different group working, like on IOs 6, 7, 8, and 2. We have one group on terror financing. Sorry, those are one group. The yellow for the regulatory side, it's the green. And the legislative side, we have another subgroup. So these are all working teams that we've had. I don't want to bore you with all of them, but just to show you how we've been approaching this. Can provide more info if requested. So, Chair, before we get on to the bill, then let me just conclude the first part of this presentation to say, so what we're doing is FATF, the main report is October, and in November and December we'll engage with what's called I guess the FATF Secretariat or the joint group. And the joint group will oversee and assess us. And it's the group for Africa and the Middle East. So Isamalek is involved with the FATF Secretariat, and those are the people we have to convince. And in January, they will then have a major meeting with us and prepare their report to the FATF plenary for the February meeting. Next slide. So, yes, Chair. So, Chair, what we're going to do now, so that's the first part that just shows you the path that we have to swim through to prevent grey listing. And, and I think it's doable. We can prevent the grey listing. We just got to demonstrate the commitment and be able to tell our story well, but also we need facts on the ground. So we've got to demonstrate this real action. I'm going to ask Advocate Smith, Puvendri, are you an advocate? Puvendri and MP van School and Janine Ben-Goyosi to come in and talk through these slides where they go through clause by clause what the general bill actually does. So over to you. Peter, do you want to lead?
Thank you, Momo. I'll come in on the first couple of slides, and then Peter and Puvendri will handle the substantial proportion on the amendments to the FIC Act. So thank you very much, Chair, and good morning to the committee members. So just to go through briefly the first parts of the bill, clause by clause, the first few provisions deal with amendments to the Trust Property Control Act, which are particularly intended to address Recommendation 25 in order to ensure that there are appropriate measures to prevent the misuse of trusts for money laundering or terrorist financing. And it's critical that we ensure that there's adequate, accurate, and timely information collected on trusts, particularly on who the trustees and beneficiaries are, and that information is collected and accessible in a timely fashion by authorities and other relevant persons. So the proposed amendments to the Trust Property Control Act address the deficiencies relating to the trustees being required to obtain full information on beneficial ownership when they are creating trusts and when trusts are being operated. These amendments to the existing Trust Property Control Act entail, first, in Clause 1, inserting definitions of accountable institution and beneficial owner in Section 1, which are necessary to provide appropriate alignment with the FATF requirements. Clause 2 amends Section 6 to specify matters that would disqualify a person from acting or continuing to act as a trustee. And these criteria for disqualification are aligned with the criteria in Section 69 of the Companies Act in relation to directors of companies, and particularly these matters for disqualification include convictions for terrorism, anti-money laundering, and other related types of offenses. Clause 3 amends Section 10 to require that a trustee disclose their position as a trustee to any accountable institution that the trustee engages with in their capacity as trustee, and also makes it known that the transaction or business relationship that's being engaged in relates to trust property. Next slide, please. Thank you. Clause 4 amends Section 11(1) to require a trustee record prescribed details relating to accountable institutions which the trustee uses as agent to perform any of their functions relating to trust property, and from which the trust property obtains any services in respect of their functions relating to trust property. Clause 5 inserts a new Section 111A that specifies information that must be kept by trustees in relation to beneficial ownership relating to the trust, and requires the Master of the High Court to maintain a register containing information relating to the beneficial ownership of trusts and provide access for the information regarding beneficial ownership. And Clause 6 creates offenses when a trustee may fail to perform duties in relation to certain specified sections, particularly those relating to the requirements to collect and provide relevant information and disclose important relationships, information relating to their duties as trustees. And Clause 7 finally amends Section 20 of the Act to specify that the trustee may be removed from office if the trustee becomes a disqualified person to continue to act as trustee. And with these amendments to the Trust Property Control Act, these will be in place for a period until a new trust property regulation of trust property bill, which is currently being developed by the Department of Justice and Constitutional Development, will be enacted. So these are urgent amendments to provide for these measures for the immediate period until the new legislation amending the trust property regulation comes into operation. The next legislation that's amended in the bill, it relates to the Nonprofit Organizations Act, and it is intended to implement Recommendation 8 to ensure that nonprofit organizations are not misused by terrorist organizations. And countries are continually required to review their laws relating to nonprofit organizations and regulations in that regard to ensure that there isn't and address vulnerabilities relating to terrorist financing abuse. So Clause 8 of the bill proposes to amend Section 2 to update the objects of the Act to align with other proposed amendments that would require all nonprofit organizations to be registered under the Act and to comply with the Act. And this is particularly important in relation to governance requirements relating to governance, transparency, and accountability. Currently, registration under the Nonprofit Organizations Act isn't mandatory. So going forward, it would be mandatory to register under the Act, and this will be important to ensure appropriate monitoring of the nonprofit organizations for these purposes of preventing abuse for terrorist financing related activities. Clause 9 amends Section 5 to insert a new subsection 2 to provide that in performing its functions, the Directorate may collaborate, cooperate, coordinate, and enter into arrangements with other organs of state. This is a general provision that is supportive of the Directorate, but also in relation to these other measures in the bill, it also particularly will be helpful in their implementation of requirements relating to maintaining registers of information relating to the interests in relation to nonprofit organizations. Clause 10 amends Section 12 to make registration of nonprofit organizations mandatory. So the Directorate will then have clear oversight over all nonprofit organizations, including foreign nonprofit organizations that are intending to operate in the Republic. Clause 11 amends Section 18 to submit for nonprofit organizations to submit prescribed information about office bearers, the control structure, governance, management, administration, and operations of nonprofit organizations to the Director. And then Clause 12 is amended to require that information to be included in the register that the Director must keep. And it also provides measures relating to accessibility of that information. Clause 13 inserts a new Chapter 3 and Section 25A in the Act to provide grounds for disqualification to be appointed as an office bearer of a nonprofit organization and to enable the Director to remove an office bearer of a nonprofit organization when that person fails to comply with the requirements of the Act or becomes a disqualified person. And the grounds for disqualification, again, will be similarly aligned to those in the Section 69 of the Companies Act. Clause 14 amends Section 29 to include offenses relating to failure to comply with Section 12 and Section 18(1)(ba) of the Act that particularly relate to these information relating requirements. So I would ask Peter and Provindri now, they could come in to discuss the amendments relating to the FIC Act.
Thank you, Janine. So I hope members can hear me. If there's a problem with my connection, please let us know, and then Provindri can carry on with the presentation. So the findings of the mutuality report that require amendments to the FIC Act relate to recommendation 7 on targeted financial sanctions. A few of the recommendations that deal with customer due diligence, and that includes how we deal with politically exposed persons and the internal controls that we provide for or require institutions to provide internal.
Okay. Good morning, honourable members. I think that Peter's connection has...
Lastly...
sorry, Peter, I think we are losing you, so I'll continue with the presentation. Okay. So as Peter mentioned, there were several recommendations that impacted on the FIC Act specifically as well. So the amendments to the FIC Act would address some of these deficiencies, as well as will improve the ratings when it comes to the immediate outcomes relating to the regulation and supervision, which is immediate outcomes 3 and 4, as well as immediate outcome 6, which deals with the use of financial intelligence. The next slide, please. And as we've also previously mentioned, many of the proposed amendments to the FIC Act relates to minor or amendments that don't change any policy or approach in the FIC Act, but the findings related where we received a partially compliant in terms of the recommendations that we outlined in the previous slide, related also to the scope of the FIC Act. So that means there were certain sectors that do not fall within the scope of the FIC Act, and this is dealt with through the amendments to the schedules of the FIC Act. So once these sectors come within the scope of the FIC Act, that will also substantially increase the ratings that we received from move from a partially compliant to a largely compliant. The next slide, please. In terms of the proposed amendments relating to the objectives of the FIC, some of the changes include specifically mentioning that the objectives of the FIC include the identification of persons involved in money laundering, terrorist financing, as well as proliferation financing activities. There's also an additional proposal to amend the FIC Act so that the FIC is able to produce forensic evidence. And this would be evidence that can be used in court proceedings. So it won't only be intelligence information, but evidence that can be used or where the person can testify in court in terms of the evidence or the production of a forensic report that's initiated at the FIC. There is also a proposal for the FIC to be able to share information with the Office of the Auditor General. This comes about due to the fact that the FIC is able to share intelligence with a very a specific set of agencies such as SAPS, NPA, SARS, and the Auditor General will be added because of the amendments, recent amendments to the Auditor General Act that allows them to conduct investigations. And then there's also just a minor amendment in terms of, again, who the FIC is able to share information with. And we've narrowed in terms of the original wording was to have an investigation division in an organ of state that conducts investigations. This is being narrowed down to a national department just to remove any ambiguity in terms of who the FIC may be able to share information with. Next slide, please. In terms of new powers, the FIC has been involved in a number of projects. I think we've lost the presentation. Or is it only on my side?
No, I've also lost it. Indira? Nandile, are you there?
Okay, so let me try again. It seems I got cut off now. I'm sorry about that. Should be on slide 22, right? Yeah.
Yes, that's correct. So in terms of the FIC being allowed to enter into public-private partnerships, this is now clearly set out in the powers. So this will, for instance, cover issues around the work that we do in the Samlet area. And the next sort of function that's been that would allow the FIC to function more effectively, as well as to address some of the deficiencies in terms of the FIC having access or sharing of information or obtaining information so that it is able to properly analyze and disseminate its information, is for the FIC to be able to request information or access from any database that is being held by an organ of state, as well as to request access to information that's contained in a register that's being kept by an organ of state. The next slide, please. I think you skipped a slide. Thanks. So in terms of some of the minor amendments that relate to the customer due diligence measures, when it comes to the requirements in terms of Section 21C of the FIC Act, it requires the accountable institution, when it suspects that there is a suspicious transaction, while it is performing the customer due diligence measures, for there to be steps to be taken in terms of when it files an STR report for that institution to discontinue the CDD process. Again, this is just to address a minor finding in terms of recommendation 10. And the same with the amendment to Section 21D of the FIC Act, which requires institutions to take certain actions when there are doubts about previously obtained customer due diligence information. So this also extends to instances where an SDR is being reported to the FIC. There are also amendments made to the offense clauses in the FIC Act, where in 2017, there were amendments made to the offense clauses that, in addition to the criminal sanction that can be imposed for failing to comply with the FIC Act, there would be administrative sanctions imposed. But it was found in practice that there were some sections that still remained with only criminal sanctions being imposed, that we needed to also consider having administrative sanctions as well as the option of a criminal sanction imposed. So the proposed amendments here are to include the administrative sanctions. And the next slide, please. Thanks. So in terms of the beneficial ownership, the changes proposed here, both the previous speakers have touched on the concerns in relation to the beneficial ownership information and the deficiencies in the law currently in terms of the scope of how we cover beneficial ownership information. So with the FIC Act, one of the proposals in order to strengthen or to enhance the definition, the proposal here is to ensure that when we define beneficial owner, we apply the look-through principle and make sure that every a natural person, whether they are holding positions in a partnership or a trust, especially, for instance, a trustee or a founder who could be legal persons themselves, should also be identified until we get to the natural person. So those are the sort of the proposals that we are suggesting for the amendments to the definition in the FIC Act. And some of this is carried through into the body of the Act itself, where in terms of Section 21B of the FIC Act deals with what an accountable needs to take, the additional due diligence measures that an accountable institution needs to take when a client is a trust or a partnership or a legal person. So these look-through principles apply here as well. The next slide, please. In terms of the changes in relation to politically exposed persons, here in terms of recommendation 12 in the mutual evaluation report, we were found to be partially compliant, or sorry, non-compliant in this, as we have a restriction or a time limit when it comes to when a person is considered a PEP. And this was found to be not in line with the FATF standards, because we currently have the provision that, excuse me, that a person is currently in the position or has held that position for a period of 12 months. So that restriction is being removed. And we also have considered changing the name from a prominent influential person to politically exposed person. And this will apply to the foreign politically exposed persons in terms of the time limit. And we've also proposing that a new Schedule 3C be inserted in the FIC Act to allow for private companies who receive tenders from government, which is currently in paragraph B in terms of Schedule 3A, be moved to a new Schedule 3C. But in this instance, we are keeping the restriction. The restriction of 12 months while during the period or preceding the time period in which they vacated that position. And this is mainly because the inclusion of the private sector goes beyond the scope of the FATF definition of who a politically exposed person is. So the time limit would not apply to this category of persons. The next slide, please. And the proposed amendments to the Risk Management and Compliance Program, this is a program that an accountable institution needs to have in place in terms of where they set out the processes or the manner in which they will comply with the requirements of the FIC Act. And this is contained in Section 42 of the FIC Act. So the Act is amended here to take into account or to include the provision that accountable institutions need to take into account, in addition to the money laundering and terrorist financing risks, they would also now be required to take into account proliferation financing risks. This is a requirement that has recently been included in the FATF standards, where previously the requirement was for institutions and countries to only take into account money laundering and terrorist financing risks, but have now extended it as well to proliferation financing risks. The second change that we are proposing in terms of Section 42 is for accountable institutions to take into account the manner and processes in which they deal with group-wide programs when it comes to branches and subsidiaries. And this is also in relation to foreign branches as well. And this will address the deficiencies that we identified in terms of recommendation 18. And in terms of an additional obligation for accountable institutions, as I mentioned, for when they have foreign or branches or subsidiaries, to make sure that the host country does has the same requirements as South Africa when in terms of AML, CFT requirements. The next slide, please. In terms of targeted financial sanctions, the FIC Act did not have or include a definition of proliferation financing. So a definition now is being included so that there are also technical amendments throughout the FIC Act, which brings in the term proliferation financing in addition to money laundering and terrorist financing. So this definition just allows for a consistent approach throughout the Act itself. And in terms of the amendment to 26A, the proposal here is for a resolution that it has been issued by the Security Council when it comes to the targeted financial sanctions. These would become enforceable immediately on the adoption of the resolution in the Security Council. This has been, well, this requirement is necessitated from the deficiency that was identified when the previous process in the FIC Act is for the minister to publish in the Government Gazette a notice as soon as it is issued by the Security Council. But this was found to be not in line with the requirements of without delay, as it was found that sometimes, for instance, if it is on if a resolution comes out on a Friday, sometimes it's not possible to have that the Gazette notice issued in time for freezing for the accountable institutions to freeze without delay. So this proposal of having the resolution come into effect immediately would hopefully address that deficiency. And an additional minor deficiency in terms of targeted financial sanctions is again, the FIC Act in terms of Section 26B sets out all the prohibitions when a person is designated or entity is designated. But the FIC Act did not go far enough to include persons who are acting on behalf of or in the direction or at the direction of a designated person. So the proposal here will also address that deficiency. The next slide, please. In terms of the amendments to Schedule 2, here in terms of the minister being able to amend the list of supervisory bodies, the discretionary power that is afforded to the minister, as it does in the other sections like 73, where the minister can either add or delete accountable institutions, or in section 76, where the minister has a discretion to delete or amend the list of reporting institutions. The section 75 does not allow the minister that discretionary power in terms of when a supervisory body is currently performing a regulatory function. So the amendments here is to give the minister that discretionary power to delete or add, and to delete when the minister reasonably believes that his supervisory body is not satisfactorily performing its supervisory or enforcement functions. And you will recall in the discussions with the deletion of certain supervisory bodies in the process when the Schedule 2 amendments were before the committee, the two supervisory bodies that were not deleted from the list were the Estate Agency Affairs Board as well as the provincial gambling authorities. So the proposal here is to then delete these from the list from Schedule 2 of the FIC Act. And the amendment to Section 4 is just a technical amendment as a result of the removal of these supervisory bodies. The next slide, please. Okay, Janine, can I hand over to you?
Thanks very much, Puvendri. So just finally, to very briefly touch on a few of the final provisions in the bill, there's a few provisions to the Companies Act, amendments to the Companies Act, which particularly seek to address Recommendation 24, which requires countries to ensure that there's adequate, accurate, and up-to-date information on the beneficial ownership and control of legal persons that can be obtained or accessed rapidly and efficiently by the authorities through either a register of beneficial ownership or some other suitable mechanism. And the main deficiencies which were identified that needed to be addressed in relation to the Companies Act relate to the finding that beneficial ownership information is not always timeously available to the authorities. So the proposed amendments to Companies Act include the insertion of a definition of beneficial owner in Section 1. And in relation to these definitions of beneficial ownership that are included in the bill, they link to the definition in the Financial Intelligence Center Act, which provides the main content of the definition and then seeks to address the content of what a beneficial owner is in the context of the different pieces of legislation. Clause 53 amends Section 33 of the Companies Act to provide for a mechanism for the Commission to keep Companies and Intellectual Property Commission to keep accurate and up-to-date beneficial ownership information and to provide for that to be accessible. And Clause 54 is amended to insert a new subsection 3A in Section 50 to provide for a requirement for a company to keep a record of the natural persons who own or control the company as per the definition of beneficial ownership, and to provide for timelines within which the company must record and register changes in this information. Next slide, please. Clause 55 amends Section 56 of the Companies Act to insert a new subsection 12 that provides a requirement for a company to file a record of the natural persons who would fall under the definition of beneficial owner with the Commission. And Clause 56 proposes to amend Section 69 that deals with the disqualification of directors of companies to insert references in subsection 8 to include references to certain offenses relating to money laundering, terrorist financing, or proliferation financing activities, as are defined will be defined in the Financial Intelligence Center Act and the Paktatara Act, and also certain offenses in terms of the Tax Administration Act. So the certain specific additional offenses would be included as grounds for disqualification from being a company's director. And then finally, Clause 57 amends the arrangement of sections of the Act. Next slide. And finally, we have a few amendments to the Financial Sector Regulation Act of 2017. And these are intended to enable the definition of beneficial owners in terms of the financial sector context, and also to enable the regulators under the Financial Sector Regulation Act to provide for appropriate requirements and provide for appropriate regulation and supervision relating to beneficial owners in terms of the financial sector laws. So Clause 58 would insert a new Section 159 in the Financial Sector Regulation Act to require that financial institutions, key persons and representatives or contractors, where a directive has been issued by the regulators, they must comply with those directives. Clause 59 inserts a new Chapter 11A and Sections 159A to 159C in the FSRA, and it specifically deals with beneficial owners. And these provisions include a definition of beneficial owner, for the purposes of the chapter. And it also provides that regulators may make standards in relation to beneficial owners. And finally, it also empowers the regulators to issue directives relating to beneficial owners. So beneficial ownership can be then explicitly regulated and supervised in terms of the Financial Sector Regulation Act and the financial sector laws that fall under the ambit of that act. And then finally, the last two clauses in the bill amend the long title and the arrangement of section of the Financial Sector Regulation Act. So that concludes the summary of the provisions of the bill. And then there's a few final comments, inputs from colleagues. Momo can provide.
Yeah, no, I'll take over. No, thanks. So, Chair, just to begin to conclude, I think I just thought I'll put up a slide for honourable members to see just the timelines for FATF, the dates on which the observation period ends. It's around 16 to 21st October. And then FATF will come back and give us detailed timelines for steps in what's called the post-observation reporting period report. And then the joint group sends the draft report to South Africa, and we then need to have face-to-face meetings around January. You can see we're going to be very busy over the December-January period. So we certainly won't go on holiday. We'll be around to engage with FATF, and then the ICRG process and so on, an action plan is around the 12th to 17th February next year. So anyway, that's for us internally, just as government, as the executive, that's what we'd be doing. Next slide, please. So just to make the point, I guess, the October report is going to be important because the FATF Secretariat will already be responding to things. And yes, whilst we can update, it would be good to have concluded from our side all the issues we can conclude. Okay, we're certainly not expecting the bill to be concluded by then. Let me just add that up front. Next slide. So, Chair, I thought I would just, I think the Dr. Tara bill, actually the hearing's also taking place now, I'm pleased to say. But this bill was published about a month, more than a month earlier than this bill. And it seems they had a 1-month process for public comments. I don't have the exact dates, but I'm just going through the parliamentary website. And they have published a whole lot of dates on their hearings, their public hearings, report back, and so on. And they appear to be planning to conclude their process by the end of September. I guess for our general laws bill, which I think Parliament published it on Monday. I didn't see it on the website yet on Monday, but there was an ATC notice on the 25th of August. And obviously, I think we're very conscious as administration that this bill is now with Parliament, and it's Parliament that will determine the process and the timelines. And obviously needs to follow and make sure that the process is done in terms of what the Constitution and law requires, and give many a chance to comment. And we do expect many comments, Chair, because of the rush, we've not been able to have a previous round of comments before the bill is tabled. So the committee will need to guide will determine the advert and deadline for public comments. I guess it would likely be sometime in September, towards the end of September, and provide guidance to us on the further process for the bill, but especially how the other relevant portfolio committees, so we've outlined the 4 of them. Obviously, there's us as finance here, but there's also social development, there's trade and industry, and there's the Department of Justice and Correctional Services that needs to be consulted. But the Police Portfolio Committee will be having its own separate process. Next slide, please. So to conclude, I think as a Treasury, we believe that this bill, if it were enacted by the end of the year and in place, would be a massive step forward in trying to meet the deficiencies that have led to the grey listing. It won't be enough. The key challenge that we face as a country is, hopefully can we pass the two bills by the end of the year? And to the extent that we can we show some progress by the end of October? The key challenge, I guess, facing the finance committees on this bill is how to involve the other committees. We will also have to show, as a department, what we've been saying is passing the bill is not going to be enough to prevent grey listing. It's a necessary step, a massive step forward. But as the executive, we're working on ensuring progress on each of the 11 effectiveness immediate outcomes by February. And as I pointed out earlier, it doesn't require the law to change yet to do this. Even if they can do this just in terms of the current laws, it would be significant. And we are developing action plans. The mutual evaluation report does have recommended actions, so that will be taken into account. And Chair, we certainly believe that as Treasury that we can prevent the grey listing, and that's what we focused on. And yes, we are looking at the possibility, as we said, was it last week on the scheduled hearing, that yes, we got to look at the prospect if we do get grey listed. Even then, I think we should only be grey listed for one or two measures. If we can show that we've made substantial progress, it will make it easy for us to get out of it after a few months. If we then just have to focus on one or two of the effectiveness measures. The steps taken to grace, and I want to end by just making the point that, I think FATF is just being a messenger here and saying there's the weaknesses in our system. Frankly, it's in our own interests, and we're acting in our own interests first, not because of FATF or anybody else, that if we take some of these measures, it will really strengthen our capability to deal with financial crimes, to prevent it, to punish it, and all financial crimes, whether they're in the public sector or in the private sector. And there's many in the private sector which need to be dealt with. So, Chair, we'll end there. Thank you. It's been a long presentation, and thanks for the patience of the honourable members. And we are ready to answer any questions.
Thanks, Acting DG and the entire team for the presentation. Let me invite members who would like to make comments and or ask clarity-seeking questions. Over to you, honourable members.
Chair?
Noxie, are you raising a hand? I can't. Can you assist? Maybe it's because today I'm using a small gadget. I can see the hand of Honorable Abraham and Dr. George. Over to you, Honorable Abraham. Then I'll come to Dr. George.
Thank you, Chair. Chair, I think my take would really be around the general performance as presented, maybe one needs to first appreciate the input by the department. My first impression is that in terms of performance, maybe compliance, we seem to be at about 50%. And I just want to check whether that is good enough. I know that 50% might not be that good, but I don't want to assume that it's not good enough. I want us to get a sense from Momo and his team as to the international performance, so that we are able to gauge ourselves in terms of where we are not dismal compared to other countries. My second take, Chair, the presentation around section 21. It's just a clarity for me there. Are we saying that the foreign nationals, when they are not naturalized, they are not able, or we do not allow them to have the kind of ownership that you would have had if you were nationalized? I think, Chair, it's just a clarity question on Section 21. What is it that we are saying there in terms of the performance of foreign nationals in the finances of our country? Thank you, Chair.
Thanks, Dr. George. Over to you.
Thank you, Chair. I'm going to leave my video off. I've got some connectivity problem this morning. Just a brief question. My understanding is that the Department of Justice has insisted on their own legislation for terrorist financing, and it's not part of this bill. I just want to know if that is so, and if it is so, then why is that the case? Because this needs to be coordinated. Thank you, Chair.
Thanks, Dr. George. Honorable Sarupen.
Thank you very much, Chair. I'm also going to keep my video off for connectivity reasons. With regards to slide 6, Chair, that was presented earlier on, where the effectiveness of the measures was one of the things that was pointed out, and it needed to be aligned to the 11 immediate outcomes, such as prosecutions, number of freezing orders of funds, etc., etc. National Treasury rightly says that this is going to be quite tough. What I would like to understand from National Treasury is, going forward, it's one thing to change all the legislation, and that's all fair and well, but what are they going to do to make sure the Financial Intelligence Center, law enforcement agencies, etc., both understand the scope of what they have to do, and then understand the how to effectively do it, so that they can, in fact, execute what is required of them, so that the country is not grey listed. Thanks very much.
Thanks, Dr. Honorable Sarupen. Let me also ask 2 or 3 questions. Thanks, Momo and your team, and honorable members. Momo, sometimes we blame other people for the image of South Africa out there. But the narrative, every time public officials take a public platform, they talk about a South Africa which is corrupt. These days I hear other public figures saying criminals have taken over. I'm not sure whether criminals are running union building, parliament, and the judiciary. But that's what you hear from public figures. And I don't hear that from other countries, that every time their public representatives and public servants take a platform, they start by saying we are very corrupt and so on and so on. I don't think that's the right narrative. And when other countries and other people say you are very corrupt, we want to blame them and say no, we're not corrupt. But that's the narrative that we give even to the people of South Africa. And I've been hearing this time and again and again and again. I said, but what kind of public officials are these ones that every time they take a public platform, they don't talk about what government is doing first and foremost. They start by saying that we are corrupt. Those who are corrupt must be dealt with by the law, and they should not be protected. And then I heard you, unless I did not understand, that there should be more arrest of those who are politically connected. So what we are going to expect from now is that we are going to see lots of political connected people arrested, even if they haven't committed any crime, so that in the eyes of FATF, you are seen to be doing something. Is this bill not about dealing with people who are involved in money laundering and terrorism? Because I understand that is the purpose of this bill. No one will want to promote money laundering. No one will want to promote terrorism in our country. But if another narrative is that arrest political connected so that you are seen to be doing something, then those people go for trial for over 10 years without any trial. I mean, their case gets exposed, postponed non-stop. And in the process, their images are damaged. And it goes with like political connected. This term political connected, you know, it is denying lots of people, even my own children as a member of parliament, they are regarded as political connected and they are not politicians. But if they want to get involved in business, they are punished because their father is a member of parliament. I don't think it's right how we treat the South African citizens. And I don't think that's what is done in other countries. To be a father of certain kids who are not interested in politics, and your kids must be punished for sins of not their own. What kind of a government are we running? I don't think that's proper, because that's what our children and our relatives go through when they apply for finance in financial institutions. I heard one of the presenters saying that there has to be a clause C that must have something to do with companies getting tenders from government. Why? What is that all about? If citizens who have companies apply to get tenders from government, why should there be a special clause to deal with those? We have got a PFMA, we have got a regulatory regime in terms of procurement and a whole range of other things. But to bring something here in this bill, I don't understand why are we doing that? We have got lots of problems with foreigners who own spaza shops, who own other sorts of businesses. I don't see them mentioned here. I don't have to mention the nationals of such people. How SARS is dealing with such people, because they trade in cash and they don't pay tax. And that's what South Africans are saying. Where is it in the bill? Are we going to regulate foreign nationals who are involved in many business activities in South Africa and they are not paying tax? And those might be the proceeds of crime and terrorism. You remember we've seen it during COVID-19, that when we thought we are regulating the sale of tobacco, liquor, there was a lot of tobacco that crossed the border into the country. And up to today, we don't know whether people have been arrested or companies have been pounced which were involved in such things. So I don't know ultimately whether before FATF, you are seen to be wrong. What you must do, prove yourself. So you are already guilty, but prove that you are not guilty. So FATF regulations are punitive and not corrective. Is that the impression that we are getting, that the country or the government is approaching FATF with a back foot, that South Africa is going to be grey listed? Why must it be grey listed? Why isn't that it's just a regular check that how far are you? But if the word is going around in the public domain that South Africa is facing grey listing, I have got a problem with such kind of a regulatory body, because I don't know whether its intention is to be punitive or is to assist the country to comply. Thanks. Over to you. Please respond to all those issues raised by honorable members.
No, thank you, Chair. And I think, Chair, you raise really important questions. And in fact, some of these questions even came up in 2015, 2016. And let me say, even in other countries, if you look at when, this concept of, let's start with that, of PEPs, politically exposed persons. It's started off with the UN and the World Bank, I think. And I guess it was a recognition that corruption, when it takes place in government, so, South Africa signed the UN Charter Against Corruption. It's called UNCOC. I think it's Code on Corruption. And it was in fact led by Kofi Annan when he was Secretary General. And they began to refer, from what I can see, just my sense of it, there was some prior writing. But when you deal with corruption, it's kind of saying that you need to take preventive measures, and that and this got signed, as you know, by most countries in the world. And it kind of says that, corruption almost by definition involves one party that's in the public sector and often one party that's in the private sector. But one party will be in the public sector because they're controlling some sort of assets or funds under government. Obviously, if it's between two private parties, it tends to be called fraud, from my limited legal understanding. That won't necessarily be corruption. Corruption has to be against public resources. So the notion of politically exposed persons came. And if you look at it, like when they brought it into the UK, many of these governments, you had huge criticism of the concept. But, governments had agreed that with the United Nations, the UNCOC document, and then it started getting implemented. So FATF started implementing it around 2010, 2011,